Okay. Pleased to see you again in the second session. Okay, how to perceive the role and its limitations of mass media involving public administration. Well, actually, I also like to remark one illustration about the U.S. economy, for example. The press has long make it or they actually prestige about this reporting. So they pointed to the worst aspect, or the staggering economy, or the kind of and they make a thematic what embedded in the key event of about the U.S. economy and gather many neighbor nature of issues. What the focus pointed out kind of a trade imbalances, what is that? A rising deficits and a weak dollar. This reporting practice actually oriented the viewpoint of public. Public opinion was determinatively influenced by this report or news coverage. Nonetheless, the actual figure to indicate the national economy would not be so worse. The period would be around time that the U.S. economy actually outrivaled Germany and Japan about the international trade. So why the U.S. Actually had begun to outperform Germany and Japan. So might create a false impression, and could it function as a basis to create a public consensus about that issue? So I now revert to the first hypothesis between two institutions, actually, and also the perception about the positive effect of mass media, along with the negative effect. Agenda setting role would actually quite consequential, and that would be a threat, and to fuel the immediate focus of a public issue. However, consider the characteristic of public policy. It actually deals with enduring issues, chronicled based on science and information. Okay, now we turn to discuss information and administration. So the public agency would act based on information. It depends highly on the evidence and the Constitution, and APA also requires to act on three pivotal concepts, as said: internet, information, science, and democratic participation, the kind of a due process concept was mandated by constitutions. So we consider two phases of information issue, or investigation, and how to frame properly and lawfully the public access to information held by government. So the activity to investigate some elements and strands in executing their duties is fairly important and fundamental in their responsibility. And this issue, we may bring some constitutional lens along with several important cases. The first case would be Wyman versus James, 1970, decided in 1971, and Marshall versus Barrows Corporation, decided in 1975, and Dow Chemical Company, which would be more recent, produced in 1986, and other issue involving immigration and naturalization service. So one concept might be drawn from the beginning on upon the constitutional amendment, Fourth and Fifth Amendments. You may well learn the basics about that amendment. What a search and seizure requirement was spelled out in Fourth Amendment, and actually a criminal for example, what is the prohibition of self-incrimination, the kind of right to confront the witnesses, and really prescribed in a Fifth Amendment, due process of law concept, and other. So there are many aspects that the public agencies have to get information. They may need to discharge their enforce the social security laws, welfare benefit, for example, and they may be compelled to visit, to make a home visit about the welfare recipient. I have accepted one scene. It was from South Korea. You see one aged man at the center, and two case workers seem to talk about the status of a welfare recipients, and also, and they need to assess if he or she is eligible to continue on the welfare alimony, what is and they may get the information in the end to determine what the status, and whether they could terminate since their situation turned improved, what is, and may could be disqualified since the household economy turns better. And also they need to make a home visit since they may explore other possibilities to subsidize, and more subsidized they may get worse. And the emergency action may be framed, for example. It is private housing, hence the welfare recipient may, in some cases, deny the request to visit. They may like to report their status in the written form, interrogatories of other than. Physical visit may be indispensable for administrative purpose, so the conflict may arise. And what is the first scene is colorful and fascinating. You may now see the area photo, the agricultural farm in Northern Europe, perhaps. Actually, the region would be abundant of plants and many the flowers, farmer flowers and others. They export to subsidize their national economy. Imagine if the photo was taken by administrative agencies to find evidence to terminate the business license or farm licenses. Or in some cases, I'm not sure if farm license is instituted of global jurisdictions. However, manufacturing industries or business operations may be subject to some monitor or inspection in the process to determine their eligibility for the license. So, does it meaningfully fall within the Fourth Amendment rights, a search and seizure? Does it constitute what aerial photographing? Constitute the search and seizure within the constitutional meaning of a Fourth Amendment? The court would generally see it should be excluded. So you may now suppose to frame the issues in some helpful way. For example, we often consider the search and seizure issue in the standpoint of a criminal activities, crimes and others. Often you may have a news seen in yesterday, for example, the investigators of a prosecution office actually was held, enforced in the first day. The occupant of a youth residence denied their access. I'm not sure if it was a warrantless search. Nonetheless, actually it was entered, perhaps in support of a co-warrant. So the issue be matched often times with a criminal searches and seizure. We now deal with the administrative enforcement in the purpose to get information, evidence about their responsibility. In that purview, we may one important concept coined by code or the fishing expedition. So you may have a viewing contrast with several cases, for example. So the suspicion is actually focused and determined to narrow the visit. Fishing, in terms of fishing expedition, the administrative agencies may not have a probable cause. So what it might be, but it might not be, and so very rough and vague to make the action of visit to be determinative. In this case, the enforcement might be seen compulsory, which could contradict the constitutional requirements. So you may have some useful frames between fishing expedition and probable cause. Often the code might be generous if it involves the kind of a provisional service of government, welfare recipients or welfare benefits and other provisional administration would not be born in similarity against the criminal, but actually it is one very traditional area of police power. Criminal muscle is actually typical to characterize the government over history and tradition. And what you have, we have some interesting words. The power to tax is the power to destroy. So the taxing power is also traditional. Two notorious areas to expect from the government, the essential responsibility in any case. However, we revert to the first of this term. Actually, now we consider the advent of a administrative state, not merely advent, and often now much rated to characterize the modern contemporary forms of government. So there are many diverse areas to make it distinct from criminal activities, criminal investigation. In that case, the code would also has a differing lens, prisms, to consider the constitutionality of action or vision. And also, you will now have some important orientation in basic perception about this class, what the private and public dichotomy. So actually, capitalist economy is one counterpart that now the modern government would respond with. So how to organize the capitalist economy to serve the ideal of social justice is important. In the case Wyman versus James, we could ascertain the kind of traditional purview or perspective, purview from the court authority. What is a social benefit, entitlement, or privilege? We generally term them as social rights. So the characteristic of this right is fairly perplexing when we consider this kind of issue. If it could be a quasi-property in some sense as equated with the kind of intellectual property, could we see it the kind of status elevated to that traditional rigidity of a concept about property or right? It might be seen as weaker, merely a privilege to claim a benefit from the government. So now let us return to the basics of a philosophy, for example, libertarianism. The camp would be marginalized who is unsupportive of a social paradigm of justice. It could not be equated a property right, merely provisional and actually just a beneficiary, depending on the government decision. Structural injustice may intervene to elevate the kind of a status as entitlement or a hard right. Then the court disposition would go in other way. Still, it could not be so hard. The Wyman's request was perceived, actually found to be merely a privilege. So his denial would be lawfully base the termination of a pension or a social welfare benefit. In this case, recipient was classed within the statute of aid for families with dependent children. And also, in this concern, you may need to know what the kind of evidentiary rule, what exclusion rule in relation with the Fourth and Fifth Amendment. What is that? A poisonous tree would be imagined, for example, or the fundamental evil to violate the entitlements of the constitutional privilege of Fourth, 15th Amendment would bring a lasting consequence about the subsequent evidence. They are fundamentally wrong. So the evidence could be properly excluded, actually inadmissible in terms of evidence law, and also therefore no probative value to prove any requirements or the statutory elements. So the evidence could well be suppressed when presented in courtroom. So illegal gathering of information would be so prosecuted in the process of a court. So interesting. And what is that? And the name Lopez and Mendes involves the immigration case. And he was a worker in transmission repair shop located in California. The immigration issue was administered in the initiative of federal government. I have illustrated one case of federalism involving state of origin. They actually enacted the new frames of deals about illegal aliens. Actually, the controversy was brought in courtroom about the federalism. So preemption could be presumed initially and might be shifted. So most hard measure was struck down by court, preempted by a federal framework or laws. So in this case, Lopez Mendoza was inquired and asked to present a documentation of the immigration status. They are undocumented workers and so illegal, and what they brought to the deportation hearing eventually. So quite devastating person. So how do you perceive this context of a public administration? That would be reviewed briefly later of this session. And also, what is that? You now see another facet of a issue. So the public also are interested to obtain information held by government. So the notable effort in this area would be realized. For example, you see in the enactment of a FOIA, Free Information Act, and also some amendments to make it mandatory to declare it is accessible or not. Actually, the scope of information is diverse in coverage of many delicacies. In some cases, they involve a national defense issue or a public safety, and also personnel affairs, privacy right, and others. So the Free Information Act actually requires a open access to the information held by government. Nonetheless, it includes also a scope of exemptions. What 10ness you will see later. And also you have some point of distinction. For example, the purpose to request the information. You may be a scholar to be interested in that area of a knowledge or others. Then you may petition to serve your self-interest. And many other contexts could be illustrated. In some cases, the request would be made in the interest of public. Then the standing requirement to pursue the grant of request in the litigation could be adjudged. So in some cases, the standing would be denied, since they are not a direct scope of a statutory purpose, merely a third-party allegation to petition. In this kind of contention, you will see some popular names. Many public interest groups in the United States are now in activities in sublime public courts. So what previously you can see a Sierra Club. What is that? Environmental issues are often the popular subject that the group focused. And a Reporters Committee for Freedom of Press. Common Cause is also a very familiar name. You can see. The Association of Fair Representation in the United States. Their prime role would be to make a concern of public issues and eventually oftentimes bring the issue to the court litigation. For example, the Association of Fair Representation in the last case pointed to some suspect of public universities, University of Wisconsin and Harvard and North Carolina was classed as suspect category that they may pursue. So a favorable action was actually disapproved, disappeared from the Michigan Constitution. It was the provision was struck down. The provision was endorsed actually. So the affirmative action now operates in embodied so we may call a reverse discrimination. So the fair competition is a theme to be advanced by this association. So diversity issue would be counter thesis oftentimes. So how do you perceive, for example, about college admission? The school administrators are required to be determinative of academic achievements of students in deciding some other elements may be considered, what we often call a diversity. And what is the scene you see in the projection? Korean panelists are now make a public speech about a new act. Actually, the Korean authority is very facile responsive with new trend. And around the times, 1990s, and they initiated many enactments of such kind of a FOIA, Free Information Act. So we now have quite ordinate extent of such laws. So disclosure, public disclosure was mandated, but of course with exceptions, scope of exceptions. The title, perhaps some conference, the act on disclosure of college and university information. So you now will see the web page, Joseon University, for example. They actually made it public to be easily accessed by many citizens about the information, key information, the number of foreign students, foreign professors, and number of graduates, and attrition rate, for example, and research funding from the government, and the employment rate at the point of graduation. So actually now we have many progress and achievements. What is a sunshine law? Also, the public agency need to hold a public meeting. So we may properly label as public meeting laws interchangeably. So that is the concept to interact with public in this informative society. What we now witness many advances in terms of e-communication, technological advancement in what actually brings a change of a living mode. So the public meeting is required extensively to determine the issue. Nonetheless, we have also extensive scope of exceptions. For example, the crucial area for the autonomy of agency was reserved. What is that? And they may exempt from proceeding required of statute. For example, in the need of a new budgeting, so it's a crucial area of competence to make them workable. So the concept of workable government was pointed out in the separation of power principle by Supreme Court. And also there are much ambiguities and vagueness in the scope of accessible information. So it is crucially important that the government may make a decision to foreground its ambit, its scope. Nonetheless, at its inception, the government may not be mandated to determine. So they procrastinate. They would let it go alone. If the public would be confused if the information has quality to be accessed to others. So the pivotal decision must be rendered by government. So they make it clear about its scope. The time frame was set forth in the initiative of Congress. So 60 days was allowed. Within that time, the government must decide whether the information is open to public or not. So kind of a development was charted over decades. So we have some useful part of the court opinion. In Wyman, the court provided the opinion on paragraph by paragraph basis. For example, in paragraph 10, the home visit is not criminal investigation, does not equate with a criminal investigation. And despite the announced fears of Ms. James and those who join her, is not in aid of any criminal proceeding. So Mr. James, in this case, is not being prosecuted for refusal to permit the home visit, and is not about to be so prosecuted. The only consequence of a refusal is that the payment of benefits ceases. So I'd like to bring your attention in view about the other case, criminal activities. So actually, often the warrant and its equivalent is constitutionally demanded in that case, and would be penalized in some case about an awful resistance, and refusal would be in this case would go otherwise. The only important and serious as this is, the situation is no different than if she had exercised a simple negative choice initially and refrained from applying for AFDC benefits. So I like to remind also the basic perspective about this issue, more philosophically. Constitutional protections for what Yale Law professor Charles Wright called new property were embraced by the court in Goldberg versus Kelly, but have not yet acquired the same level of protection afforded to the traditional property interests. Basically, both Wyman and Sanchez conceptualized welfare benefits not as an entitlement, but as a privilege that required beneficiaries to surrender the constitutional right to privacy as a condition of receiving benefits. The Sanchez case involved in San Diego County Police and also aroused in the context of warrantless home visit to establish welfare eligibility. And in the case, Marshall vs. Barrow, the Occupational Safety and Health Act of 1970 was contended. It empowers agency officials to carry out warrantless searches for safety hazards and other violations at any employment facility within OSHA's jurisdiction. An OSHA inspector went to customer service area of Barrows Incorporation, an electrical and plumbing campaign in Portalio, Idaho, and informed the president and general manager that the company had turned up in the agency's selection process. Actually, they face a crisis in pursuit of their business operation. Although no specific complaint had been received by OSHA indicating the Barrows Incorporation had violated OSHA regulations, the inspector asked to enter the business area. After Mr. Barrow refused OSHA's request, a federal district court ordered that Barrow admit the inspector. Barrow refused and sought injunctive relief against the warrantless search. So the appeal was successful, and the appellate court granted a declaratory judgment that the act is unconstitutional insofar as it purposed to authorize inspection without warrant or its equivalent, and to an injunction enjoining the act's enforcement to that extent. One in case titled Dow Chemical Company versus United States, the EPA hired a commercial area photographer who took pictures of the facility while flying in lawful navigable airspace. So EPA did not seek an administrative search warrant. How do they are so inventive or actually novel to explore this option? The code, as I have introduced, would not render it within the scope of a search and seizure. Well, actually, we also concern of a cost-benefit test. It includes the one established in Lopez Mendoz. It actually seems to have a reassuring ring of objectivity. So, how do you apply a balancing test in the immigration administration? It's often it might require a heavy burden. For the federal government may face a strong need to hire a number of new public employers, over 20 or 30, 100 new officers to enforce the immigration law. If any stringent standard of a public policy would be mandated by court ruling. A number of cousin criticism can and have been made of this approach. First, in criminal cases, it is often too easy for a court to conclude that the interest of state in enforcing its laws outweighs the right of individuals to be free from the government intrusion complained of. Judges at all levels of justice system may find it difficult to apply the exclusion rule in a principled way, where that would mean throwing out incriminating evidence in cases of drug smuggling. So actually, our reality would not be so profuse. So you may get into any island, a kind of a autonomous domain to manipulate all the matters in your own initiative waters. That is not the situation we face in the public deals So the evidential rule is also important, and also it might contextualize the public comprehension about the values and others, and equal right to counter the witnesses and others. Many details of evidential rules have been developed to ensure a fair trial. So actually practical and tangible to require many burdens or many other points of consideration. So cost and benefit analysis actually important, and that is also one area that scholarly debate has long been focused. For example, in the holistic picture, what is the government role? What is the transactional cost to make the society efficient? And so you may imagine to also between efficacy, efficiency, perhaps, and social justice, public justice. The rule that illegally seized evidence may be used in administrative cases was relied upon by New York Appellate Court in 1993. In that case, a bag of marijuana was obtained during an unlawful search of a police officer's car. And the court ruled that in disciplinary action against the officer, the cost-benefit calculation properly tipped toward protecting the public. So exclusion rule may not be wholly governing of all instances brought in similar strengths. Depending on the circumstances, situations, it could be relaxed by terms of a court ruling and others. So, immigration issues are a center stage in current discussion about administrative searches and the Fourth Amendment, where the non-citizens enjoy the same constitutional rights and protection as the citizens has been debated for a long time with no clear answer. It is usually accepted that certain rights, such as habeas corpus, are available to non-citizens, while others, such as the right to bear arms, may not be. So the issue also requires a distinct approach on an individual constitutional provision. That is also the same way of approaching Korean Constitutional Circle. For some set of rights, the aliens may not be qualified. The right to election, are they lawful to put their vote in the public election poll? And how about the right to public office? So the basic liberty, which is fundamental to personhood, must be guaranteed. Such as habeas corpus would dispose that concern, and Universal Declaration of Human Rights would be classed in categories. So the first part would largely pertain to the basic human rights, liberty rights, habeas corpus. But in kind of constitutional right to labor and social welfare benefit. In one peculiar provision would be Second Amendment in the United States, the right to bear arms. Actually, it bring a turbulence in terms of public policy, whether it could be sustained. And often major populists of the United States sustained to bear arms. Yes? And it was guaranteed as a matter of constitution. The comma debate is notable. It was a so classic document, and we may like to revamp and how would we press to list any different receipt of that provision. So comma might alter the meaning of a provision. So we call a comma debate. In any case, now we see it quite difficult to make amendments. Since the terrorist attacks of September 11, 2001, however, national security objectives have exerted a greater control over administrative practices, including searches conducted by the Immigration and Customs Enforcement Branch of the Department of Homeland Security, which replaced the INS. So the focus of public policy attention was shifted, actually. Previously, the illegal aliens were considered in a view of a national economy. How they, much extent, do they contribute to the national economy? So, and how do we conceive them? What are they a factor to make the citizens lose their job, or they say the situation turns quite marginal. What actually terrorist attacks is make a profound impact on the sensibility and comprehension of United States citizens. So all the focus was put to the national security. David Harris observes that immigrant questions was concerned with the impact of country quarters on jobs and the economy. It's now processed through the lens of national security and the war on terrorism. And you may know the word immigration raids. So the immigration officers of the United States become rather radical or fierce, specifically in some cases, communities in county jails and businesses who capture. Fear has gripped immigrant families across the country. One sensational report made by Julia Barbas as federal agents raid neighbors, work sites, and jails in nationwide crackdown on illegal immigration. Tens of thousands of people have been rounded up over the past several months, and many more are afraid to leave home, answer knock on the door, or leave their children alone in fear they might be next. So, we studied briefly the mass media, role of mass media, how to consider. So actually, the mass media plays an important role to frame agenda settings. And many newborn nations after World War II would be deeply indebted to what the press of a advanced countries, or BBC or others, CNN, for the ABC, they disclose the hidden side of a discrimination or oppression or dictatorship, and they actually help to fuel the democratic resistance in some cases, and eventually restore regime as democratical. Emblematic of this trend was a 2006 immigration raid conducted by ICE at 6 meat packing plants in the Midwest owned by Swift and Company, one of the largest meat processing corporations in the world. As a result of the raid, 1,282 workers were arrested, or immigration violations, or existing criminal warrants in the largest such enforcement action in U.S. history. RC did obtain civil search warrants before the raid, which allowed them to search for and apprehend any undocumented worker. How do you see a fixing expedition in this context? The court, for the seriousness of issue, would not be active to suppress the activities of federal government. They avoid to issue in the version of many scholars. Of course, would not would based on the conscience and legal intelligence. It actually socially make a very profound impact. So the scholar would urge if the court would advance to rule more substantially, it would not be a good practice in their purview to apply standing rules. Actually, they could not dispose the case in a subjective matter. A recent and alarming example of this trend can be seen in National Security Agency warrantless eavesdropping controversy. So many interesting stories. Also some progeny of progress in that practice. Snowden, he actually now in asylum. In what country does he is he present? So he revealed this secret practice, impermissible perhaps in his conviction. So what is that? Perhaps thousands of people inside the United States without warrants over the past 30 years in an effort to track people, dirty numbers linked to Al-Qaeda. So American Civil Liberties Union, one popular name we encounter oftentimes, filed a lawsuit challenging the constitutionality of so-called terrorist surveillance program that allowed NSA to track communication without warrant. So later, the FBI director makes some public concession about that and others. So may suppose some pivotal players in democratic process of a society, nation. So we have many very good will, kind of goodwill, when we see the kind of a NASA disclosure about the universities, the TV news. Said NASA webpage made them important achievements of their work for the public availability. So we now can entertain that esoteric scene, universe, quite useful, but in some areas may bring us to wrinkle. Okay. That will be all for this class. For the rest of issues or a court opinion, we may have some furtherance in the next class. That will be all for this class. Thank you for your attention.